Hi guys, welcome back to Bat Okitola. This is Mujela Oluwa, and on this episode we want to talk about guarantors and guarantees. Guarantors and guarantees. Who is a guarantor? A guarantor, in plain terms, is a human collateral for a loan or a debt. What do I mean? You know how when you go to the bank and you want to get a loan, they ask you to collateralize, like to bring something as collateral for the loan. It could be your house, landed property, or documents of, important things that are worth, or equates to enough value to settle the loan in the event that you default. That's exactly what a guarantor is. I'm explaining this in simple terms. I'm not equating guarantors and collaterals, but I'm just trying to explain so that you understand in simple terms. So essentially, when you want to take a loan or you want to be indebted to someone or take out a contract for a sum or something of the sort, you're asked to bring a guarantor who is indemnifying you. Essentially, the guarantor is saying to the creditor, the lender, that in case this person is unable to fulfill their obligations or pay up what they owe, I will pay. So that's essentially what guaranteeing something, or what a guarantor is in that context. So essentially, a guarantor is someone who undertakes to pay off a debt in the event of default by the principal borrower. Now, guarantors are applicable in different scenarios, but in particular, I want to focus on a loan scenario, because I'm saying that because in some forms of employment, you're asked to bring guarantors after bringing referees. So essentially, the guarantor is to say that you're of good behavior. They know you, they know your whereabouts, they are familiar with you, have known you for a certain number of years, and that you will not abscond, you will not make away with the company's monies or properties, or you'll essentially be of good conduct on the job, and they can guarantee that you're fit, you're proper, and whatnot. So, but in this context, we're talking about a loan. So what's a guarantor in the context of a loan? A guarantor is that third party that comes into the contract to say to the creditor that in the event that your debtor defaults and is unable to make good this loan, I will pay it for them. So that's essentially what a guarantor is. Essentially, when the principal borrower defaults, the creditor, the lender, can go against the guarantor to recover the loan sum or the debt. So what are the duties of a guarantor? They are generally just two: to ensure that the debtor pays the loan as due, or in the event of a default, to rise to the occasion and pay off the loan or the debt for the debtor. So those are the duties of a guarantor. Now, how does the creditor activate the guarantorship? All the creditor needs to do when the debtor or the principal debtor has failed to pay up a debt or a loan that is due is to go against the guarantor and call upon them to pay off the debt sum. The court has held this in the case of CBN and Interstellar and a plethora of other cases. Once the principal debtor defaults, the creditor can go against the guarantor, asking them to pay off the debt. So that's how to activate the guarantorship. And the court has also held in a plethora of cases, for instance, in Crown Flour Mills and Olokun, in Yemoli and Access Bank, the court has held that the creditor does not even need to join the principal debtor in a suit against a guarantor. The creditor does not even need to join both of them. Once the debtor fails to pay as due, a liability arises upon the guarantor, which can be activated, which can be laid claim to, upon which claims can be laid rather, by the creditor to recover the debt sum. To establish the tripartite relationship between the creditor, the debtor, and the guarantor, a contract is executed, which is known as a contract of guarantee. In most cases, for instance, if a debtor is taking out a loan from a financial institution, there's a guarantee form that is filled. That's essentially what a contract of guarantee is. So the guarantor is signing and saying that, okay, this binds the three of us. It's supposed to be two parties, the debtor and the creditor. But now I'm coming into the equation to say that when things break down, for instance, when this party that I'm coming with, which is the debtor, fails in the obligation, I will rise to the occasion. I will do what they are supposed to do, and I can be held as though they are being held in the event of a default. So that's essentially what a contract of guarantee is. Who can be a guarantor? Anyone can be a guarantor who can undertake to settle the loan or the debt or indebtedness of any other person, in a creditor, debtor, or lender-borrower relationship or contract. But essentially, a guarantor should know what they're getting into by scrutinizing the loan contract very well, knowing the terms, the term of the contract of the loan, the repayment period, the repayment installments, and all the duties and responsibilities of the debtor that they seek to guarantee. And also, they must keep in touch with the debtor and ensure that the loan or the debt is being paid as due. And they must bear in mind that in the event of a default, they are the next person in the line, of recovery, to be held responsible for the debt. So it's important to know what you're getting into if you want to be a guarantor. Also, a guarantor can limit their indebtedness. You could say, for instance, if someone is taking out a loan of 2 million naira and they've asked you to be their guarantor, or you want to be their guarantor, you could limit your liability to 1 million naira to say that in the event of a default, I will only be able to guarantee paying 1 million naira off on their behalf. So that will be clear to all parties. Essentially, it's simple. There are no hard and fast rules. Each person, each party to the contract of guarantee must understand what they're getting into and how, the responsibilities that arise from such a contract. Very important. How can a guarantor terminate his guaranteeship? A guarantor can do that in a few instances, just like they are similar to instances where contracts can be lawfully terminated to a large extent, and those are in cases of fraud. For instance, if the guarantor discovers that there has been fraudulent misrepresentation which led them to believe the debtor and to actually undertake to guarantee the debt. In cases of undue influence or having been compelled to guarantee the debt or the loan under duress or threat, and of course deceit. Where there has been any of these three instances, a guarantor within reasonable time can move to terminate the guaranteeship. But essentially, it's important for a guarantor to move fast, before things get out of hands and before it can be presumed that they understood what they got into and went on with it anyways. There was a case that was brought to me some years ago, I think 2 years ago. So what had happened was that a man had taken a loan and asked his sister to be his guarantor, and then I believe it was without the sister's knowledge or something of the sort, and then he had absconded with the loan sum, and then the creditor had gone after the sister and arrested the sister with the police. In Nigeria, of course, you know that people get other people arrested by the police, for different reasons, even for purely civil matters. So the sister was arrested. She was an upstanding citizen working and making a meager salary, I think as a teacher or something of the sort. She could not even afford to pay the loan back. And then she had talked to the police and begged them to release her, that she would pay back the loan in certain installments, but she could not meet up with the installments because of the constraints of her own earnings. And so she had come for us to mediate in the matter, to negotiate smaller terms or smaller installments that be convenient for her to pay off. This was her blood brother, and he had absconded and left her to deal with it. That's to show that it's important to enter into guaranteeship for someone that you actually trust, and to be very careful even when you trust them, because when it comes to money, a lot of things can happen. But guaranteeing a loan can be very useful and helpful to the debtor, in the sense that it can help them get a lot of things done, especially if it's a loan taken for an investment or for a business or a noble cause. It helps them move faster if they can get the loan or get the capital or whatever it is that they need a guarantor to guarantee for them. But conversely, the guarantor must protect themselves, by all lawful means possible. And in the event that the guaranteed debtor, defaults, a guarantor must have it at the back of their minds that they are the next in line of recovery of the debt. The creditor, by law and by judicial precedence, can call them up to pay up the loan sum and can take out a lawsuit against them to enforce, the repayment. So that's all I want to talk to you about in this video. I hope you've learned something new. Leave me comments in the comment section and bring someone along to Bar Talk with Ola. I will see you in my very next video. Don't forget to subscribe. Toodles!